marriage, he undergone a second marriage. So according to section 18, he his second marriage was invalid. Also, section 35, he has convicted bigamy. So this was what has decided in the case of Abhay Sundar versus Abhay Sundar. Right, this is about the marriage cases, and there's a board called quasi board. Quasi board is specially established for the Muslims couple. Actually, Muslims are not, it's me, in their religion, they are not permitted to formal courts to appear in the formal courts. And for that, specially, the quasi board has established for their regarding their matters. So, if any decision regarding the marriage or divorce or something, any matter regarding Muslims, if quasi board grant decision and the parties were not satisfied with the quasi board decisions, they can appeal that decision to Supreme Court. Right? Next. Also, regarding the we call that any claim of maintenance from father or any claiming maintenance from husband to the wife, if any uh, maintenance should compensation should get from the husband or any party regarding Muslim matters, quasi board can send the request letter for MC court. It's mean magistrate court, right? Can send request letter to MC court to issue warrant regarding retaking maintenance. Next is another additional information about the marriage. There's a compensation we called kai kuli, right? Kai kuli is the fund or money which given by the parents to the bridegroom for the maintenance of their daughter, right? This is the contract, right? The marriage in Muslim was a contract. So the parents will give to the bridegroom to maintenance of the daughter, of their daughter. That is we call kaikuli. And mahar is the also bridegroom, right? The husband or bridegroom give to the parents has a compensation of their wife to get the wife to marry their daughters. Bridegroom gives some sort of money or amount to the wife's parents. That is we call mahar. It is equal to the dowry. Then sadak is the gift for the wife from husband. So there are three things: kaikuli, mahar, and sadak. Okay, then next, a different topic. This is also part of law of persons, adoption. In the adoption, a case regarding the adoption, I'm going to explain here. Gauss versus Gauss, 1986. Right? In this case, actually what happened, we are going to explore the facts of this case. A Muslim parents or Muslim couples adopting a child from the Adoption of Children Ordinance number 24 of 1941. There is no special ordinance regarding the adoption of Muslim child or adoption of a child to a Muslim couple. There's no separate ordinance for Muslim people. the ordinance which govern the general law, the Adoption of Children Ordinance number 24 of 1941 applies in every scenario. So here, the Muslim couple has adopted a child according to Adoption of Children Ordinance number 24 of 1941. And the question raised here, the legal issue was whether the adopted child, can be inherited by their adopted parents. We know inheritance is given by the generation to generation, right? So from father or mother, the born children will get the property of their parents. We know that inheritance. But in this situation, the child is not born to their really born to their parents, right? Muslim couple. That child was an adopted child. So the question raised here, whether can this adopted child, inherit from their Muslim adopted parents? Right? So here, we have to know that the inheritance will govern under the Muslim intestate succession ordinance. We know that, right? So, however, the inheritance will be governed under that ordinance. So, what is the judgment came here was, yes, of course, the adopted child also have rights on inherit the adopted parents' property, because Adoption of Children Ordinance give the rights to the adopted child to inherit from their adopted parents. Around the Muslim people also, the adoption will be governed under the Adoption of Children Ordinance, which is general law. So according to that, rights will be provided to adopted child, and also that inheritance will be governed under Muslim Intestate Succession Ordinance 1931. Okay. Next is the divorce. Actually, in Muslim law, male can easily take the divorce from the wife, but wife cannot easily take divorce from husband. So male, if the husband pronounce talak for 3 times, it means the marriage was dissolved. It is terminated if he pronounced talak, right? But for the female, if she wants divorce, she need to prove the fault on the husband. What is the fault? So it's basically that divorce called as fasa divorce, right? So what are the grounds for that divorce? Adultery, physical or emotional abuse, abandonment, cannot live together, these things. According to the fault, fasa divorce, I'm telling. Not all around. I'm telling, according to fasa divorce, these are the grounds: adultery, physical or emotional abuse, abandonment, and cannot live together. Abandonment means neglecting the partner, wife, or wife feeling loneliness, right? Another type of divorce is there, Khal divorce. Khal divorce means wife leave the husband. Khal divorce. It can be Khal divorce. There's some pronunciation for will be there. I'm sorry. Next, Mubarak divorce. Mubarak divorce means husband and wife mutually separating, right? It's based on mutual consent. This is about the divorce. Right. Next, loss of property. Loss of person, it is on marriage, divorce, adoption, majority, and then guardianship. Loss of property, we are going to say first is intestate property. You know what is intestate property? Intestate property means there's no last will on the property of a dead person, right? Without the last will of, of the dead person, the property will be how the property will be shared, right? That is intestate property. So here the intestate property will decide as after all the cost of the death ceremony of the dead person, the remaining amount will taken as intestate property of that person, right? Here, that is the main point. After all the settlement of the death ceremony of the died person, that balance amount of the property will taken as intestate property. Then inherited property. In inherited property, you know what is inherited property? From the parents, children getting property. In inherited property, we are going to see a case, Bandirala versus Mariam Nachia, 1912. Bandirala versus Mariam Nachia, 1912. In this case, what happened? Actually, Muslim daughters from father can get the property, actually, right? They can get property from the father, right? What amount they can get? Actually, in Mohammedan code, which is operated in Sri Lanka, it stated 3 out of 4 will inherit to the daughter, right? But in Islamic principles, 2 of 3 will inherit to daughter. But actually, what happened here? Islamic principle is not operating in Sri Lanka. Mohammedan code is operating in Sri Lanka. For that, 3 out of 4 portion of father's property will inherit to daughter. That is the decision which given by the court. That is regarding the inherited property. One of the case. Another case we had to see here, Tilaratna versus Samsidin, between 1900 year. In this case, Tilaratna versus Samsidin, it actually is not regarding the inherited property, but I have to tell this regarding the property, loss of property, right? I like to tell this case in this moment. Tilaratna versus Samsidin, 19. In this case, married women, right, administering immovable property, right? The question raised whether a married woman cannot administer immovable property, right? What is the right on married women to administer immovable property? Actually, the Mohammedan code was silent in this particular matter, right? Mohammedan code was silent. So, we know there's the practice in Sri Lanka with whenever the special laws have gaps, lacuna, right? The Roman Dutch law, our general law, will used or fill the gaps of special laws. So here Roman Dutch law fill the gap of this, and in Roman Dutch law we know without husband consent, married women cannot administer any property or transfer something, right? So according to this case, Roman Dutch law fill the gap, and in Muslim law also, husband consent was needed for married women in mobile properties operation. So, because of Mohammedan court was silent in this particular matter, the Roman Dutch law was affecting the femisol of Muslim women, right? Femisol means the women can do according to their own will if they marry or not, right? That is femisol. So Roman Dutch law here affecting the femisol of Muslim women in Sri Lanka because the Mohammedan code was signed. Right. Next, donation or gifts. Right? This is not law of property. This is donation of gift, a separate topic. Right? Donation or gift in Muslim law, actually, Muslims can choose to whom property should handed over. They can choose. Actually, in Canadian law, definitely the parents' property should inherited to their children. That the property cannot go outside, right? If it is the last will or any written any gift or something can. But in Muslim law, that is not nothing like that. The Muslims can choose to whom their property should handed over, right? They can revoke their gifts. If gift provided to somebody, the donor can revoke anytime. Anytime can he cancel the gift and retake it unless it's stated as irrevocable in the contract. Okay. Also, widow can accept gifts. Right? Widow also can accept gifts in Muslim law. There's no problem if the widow wife getting gifts and all. And also in Sri Lanka, not in Islamic principle, in Sri Lankan Muslim law cannot offer fide commission gifts. Right? Fide commission meaning there's conditional gifts. In Sri Lanka, Muslims cannot offer conditional gifts. Okay. Now we're going to see a case regarding fide commission. The case was